Next, the United Nations top court has started hearings on the legal obligations of countries to fight climate change and the consequences of contributing to global warming. Well, the International Court of Justice will hear testimony from nearly 100 countries. The results are not legally binding, but the outcome could influence legal action around the world. Well, this was the reaction outside court from Pacific Islands students fighting climate change, a group which was instrumental in bringing the case to the ICJ.
So it still feels like a dream that we're actually here. We've been saying that we want to go to the ICJ, and now that we're here, we're very honoured to be able to be given a chance to actually address the judges, and we said what we wanted to say, so we're very happy that that was possible.
Let's speak now to Margareta Vavinka Singh, leading legal team for the Pacific Island of Vanuatu. Thank you for coming on the programme. So what is your central argument here?
The central argument is that the conduct that has caused the climate crisis is unlawful under international law, and that as a result, those responsible incur legal consequences, which includes having to cease the unlawful conduct and making reparations for the injury.
So you believe the action taken by countries that have increased global warming, producing climate change, need to pay compensation effectively to that to countries who haven't caused it but are potentially suffering the impacts?
Exactly.
And but this has no legal standing. Can you just explain the legality of this?
Yeah, so it's true that the advisory opinion itself, as the name suggests, is not legally binding. However, the court is actually interpreting or clarifying existing international law. So what the court says is very much about law that is already binding on states. And so if states do not do what the court indicates needs to be done under international law, those states will actually be in breach of their legal obligations.
I see. And we have lots of countries will be represented at The Hague putting their points forward. Just talk us through what is expected to happen.
So we see a little bit of a schism between states and organizations, because also 11 international organizations participating, states and organizations that wish to see a strong outcome and those that want to see an outcome that essentially is not going to make much of a difference in practice and will retain the status quo. And broadly speaking, those in the latter category are arguing that there are no meaningful obligations under international law to address climate change other than those contained in the climate treaties, that is the UN Framework Convention on Climate Change and the Paris Agreement. So these states argue essentially that as long as we put forward climate pledges under the Paris Agreement that we are required to do, as long as we do that, we are in compliance with our obligations, and the court should more or less stay out of the matter. And then the other side of the spectrum is the most affected, the climate vulnerable states that say that the Paris Agreement is relevant, but there are other obligations that are also relevant, such as human rights obligations, obligations to respect the right to self-determination, obligations to protect and preserve the marine environment, obligations to not cause transboundary environmental harm. And all of these obligations, when you take them together, it's clear that then states are not complying with these obligations because of their acts and omissions that already have caused significant harm to the climate system and other parts of the environment, resulting in already violations of these rights. And so claiming that the court should essentially intervene in the situation.
I see. I see that, and I'm outlining the obligations there, and that second part, which we touched on right at the beginning, of potential consequences for states. What are the range of possibilities for consequences here?
But the consequences under international law of any internationally wrongful act or violation of international law are always, as a matter of principle, the same. And so they're always twofold. First, the wrongful conduct has to stop. That's obvious because the compliance with the obligation has to be restored. States have to do what they were supposed to do in the first place. And then if the violations are it will be appropriate for states to offer guarantees of non-repetition. So
I see.
some kind of a certain assurance that these the obligation, the violations won't happen again. And the second is the obligation to make full reparations for the injury caused by the wrongful act.
I see. Margareta Vavinka Singh, we have to leave it there, but thank you very much for coming on the programme. Thank you.
My pleasure.
Around the world and across the UK, this is BBC News.